the West Coast, a very good morning. Thank you so much for joining us today. As the first words on this particular slide say, this is an urgent webinar, and we're very thankful for you to join today. There's a lot of webinars going on this week, but we figured it's an important one for us to join as well. And this is actually webinar number 7 in the series that Verisk Marketing Solutions and PX have hosted over the last 12 months to talk about the previous mandate of the FCC in regards of primarily one-to-one consent, but also logically and topically. And as you probably know by now, there's quite some developments in the last 6 days or so, 6 days, since last Friday. And we wanted to talk about that. And doing so, I am honored to be joined today, first of all, by my good friend Eli Schwarz, the Chief Strategy Officer at VMS. Eli, welcome back. You're a dad now. How is that going?
Aw.
Thank you. Appreciate that. Yeah, it's going well. It's hard to believe. Last time I was here with you guys on one of these sessions, quite a lot of things were different from what we're going to talk about today. But one of those, on the personal front, I became a dad. So that's been good. I'm learning a lot.
Congratulations.
Awesome.
Thank you.
Yes. You look very rested, so let's see how that's going to be after this session. Michele Shuster, thank you so much for coming back. You're obviously our VIP rock star that has joined us at multiple occasions, and I'm excited to go deep today to understand what the heck happened in the last 6 days. So welcome.
Flattery will get you everywhere, Bas.
Eli, you want to take it away?
Yeah, for sure. We'll go ahead and kick off here by sharing the agenda for, I think, what we're hoping to cover. I think many of you probably are feeling somewhat similar in the sense that I think a lot of us are going through whiplash with what's recently occurred, even with a couple of days to have started to digest what it all means. It's still quite a change from where we were last week. So a lot of feelings with that, and more we can talk about, where we're headed. But what we're hoping to do here, we'll start off by just explaining and trying to get everyone grounded in understanding what happened at the end of last week, understand, what the outcome was from the FCC's update, from the 11th Circuit Court's ruling, and I think, and then talk about the impact of those decisions. And we'll look to Michele to guide us there and help provide legal expert opinion on what occurred, so we can all understand clearly where what's happened here. And then we'll start to shift gears a bit, and I think we'll talk a little bit about what we're seeing from PX and from Verisk in terms of our perspective on the industry, and how we see things evolving given the changes. And then we'll roll from that. Bas, if you'll hit the next slide. We have, I think, some interesting learnings that you're prepared to share with us that PX has found with customers who were making progress, adopting one-to-one consent flows, and building out brand explicit consent, and seeing higher performance and quality from those experiences. So I think some silver linings and learnings from the past few months that we all hope are likely to continue into the future here and be a good thing for lead buyers and lead sellers, even in the absence of the regulation as a requirement to go do that. So more to discuss and share. Excited to see some of what you all have learned, and then I think we'll close off with outlook on the future, and where we think we're headed, what it means in terms of the consumer experience, and some of the problems that still exist today that we probably want to continue to work on despite the change in regulation. So, and of course, I think throughout here, we're gonna, we want to have open Q&A. So feel free to drop your questions into the chat, speak up. We've tried to make these series super interactive, and are ready and willing to try to address questions on the spot. So with that, I think, Michele, if we could turn over to you and just ask you to kind of give us the rundown on what happened last week, and help everyone get grounded. I know you've been making the rounds in lots of different forums to help explain and help interpret what happened. And if you could get us all on the same page there, that'd be great.
I have to tell you, it's been a really fun week to be a lawyer. It's just so many interesting things that have happened really in the year and a bit that's been leading up to this, but especially in this last week, and kind of takes you back to your law school days and a little bit of constitutional law, understanding a little bit about executive agency powers, and we saw that all on full display over the last week. And just by a little bit of background, and I'm going to be very quick about this because I know most of you are very aware what has been going on, but the FCC entered into rulemaking at the end of 2023, and they redefined the term prior express written consent, which is the type of consent you need to use regulated technology. So if you are making marketing calls using an automatic telephone dialing system, a pre-recorded, or an artificial voice, you need this prior express written consent. And so the FCC, and the part that's relevant to this, said that in obtaining prior express written consent, contrary to what the statute says, the TCPA says, you have to have it on a one-to-one basis, one seller, one consumer to, or one consumer to one seller. So you couldn't consent to multiple sellers at the same time. And then whatever form it is that the consumer is providing consent, it had to be logically and topically related to the subsequent telephone call. So we've all been dealing with that for a little over a year now. And so a coalition of insurance marketing companies called the Insurance Marketing Coalition filed to challenge that rulemaking. And they did it on the basis that the FCC had exceeded the scope of its authority granted in the actual TCPA statute, and that there was nothing in that statute that said that the FCC could limit the ability of the consumer to consent to more than one company at a time, or that consent needed to be logically or topically related. So if a consumer wanted to consent to, 5 companies, and we'll talk a little bit about clear and conspicuous here in a moment, but if they wanted to do that, then they have the right to do that. Nothing gave the FCC the ability to take away that right. And there was nothing that said that a consumer couldn't consent to receive a call about a debt consolidation loan at the same time they were filing or providing consent for a loan company to call them about a loan on a car. And so, and I've just been, I love this language. So I've been reading it, Bas, on those webinars that I've been on. And, the 11th Circuit said, FCC, agencies only have those powers given to them by Congress and enabling legislation. And going on to say, Congress drew a line in the text of the statute between prior express consent and something more burdensome. Rather than respecting that line that Congress drew, the FCC stepped right over it. Drop the mic. FCC rulemaking gone. So, that happened late on Friday. And immediately before that, the FCC had stayed the implementation of the rule. I don't know if there was some conversation FCC led finding out from the 11th Circuit that was going to happen, or there had been an executive order reached early or released earlier that week where President Trump was telling agencies to consider delaying the implementation of rules that hadn't taken effect yet. Whatever the case is, it happened. And so now there is no one-to-one consent requirement. There is no logically and topically related requirement. And that is full stop. That's where we are right now. And we're going to talk about this here because that's not really the end of the story, because now we go back to where we were before January 27th was going to take effect. And we have all kinds of standards that are still required for consent to call somebody that's on the do not call list, or to call somebody with regulated technology. And those haven't gone away. And I can tell you that there have been lots of cases filed by plaintiffs' attorneys who have been hiring associates like crazy to file just a ton of litigation in the wake of the rules. And those have been filed already, and they're taking the TCPA as it is now, as it was before those rules would have taken effect. And they're saying that those lead forms are still deficient. So now is not the time to let up your guard and say, oh, now we don't have to worry about anything. It's a free for all, and the language doesn't matter. We can go back to marketing partners list. That is not where we are now. If anything, the courts have really been looking at over this last year what the requirements are for consent. And the words that you are going to hear now instead of one-to-one are clear and conspicuous. And the logically and topically, you're now going to hear readily apparent to the consumer. And those are words that don't have the exact precise meaning that the FCC was putting on with these new rules, but they still do require that the consumer understand what they are consenting to, that it be clear and conspicuous, and it readily apparent that they are going to receive telephone calls as a result of filling out that lead form. And that's where the litigation will be for this foreseeable future.
So, Michele, can I just highlight two things you noted in there, which are maybe super obvious, but just to make sure everyone's crystal clear. The first one, and I think there was definitely confusion and lack of clarity on Friday, and hopefully since then everyone's kind of figured it out. But because the first event, right, was the news from the FCC where they were staying the order, the first thing that went out was there's going to be another year before this stuff gets implemented. Quickly thereafter, the decision from the 11th Circuit Court came out and actually vacated the order altogether. So there's no longer this waiting period. We're not looking at another deadline in the future, right? The initial stay is irrelevant at this point, and it's the order's vacated. Is that the right way to think about it?
That's correct. And FCC cannot act in the same way again because the 11th Circuit has said you do not have the authority to do that. And so not only is it not going into effect, it can't go into effect unless Congress changes the TCPA.
Super helpful to clarify. And then the other point, I think, which is, again, critical to understand, is that this does not mean consent is no longer required, right? And this does not mean express written consent under the TCPA is going away. In fact, there's no change to the requirement as it was Thursday last week to what it is today. That's still in place. The only thing that's gone is the one-to-one consent change, which never became a change at this point, right?
That's right. That's right. But I will tell you, something else kind of happened during this rulemaking that everybody had everybody looking at the TCPA regulations again, because there's a lot of underlying commentary by the FCC and the numerous exceeding 100 pages of rulemaking and multiple releases that really kind of put things in a different light. Like, one of the things that we have focused on over the last year now is the FCC said that, e-sign means, and just to back up, e-sign is a federal requirement that if you need to provide disclosures to consumers in writing, and it requires a signature, and you're going to do that through an electronic means, you first have to get what's called e-sign consent to provide those disclosures electronically and to get electronic consent. So just the order is consumer has to agree to e-sign. Then you can give consent language because they've agreed to receive it in electronic form. And then you can have electronic signature for that. And so, that isn't something we were really focusing a lot on. I mean, we would put something in e-signature or in a consent form that said, I'm providing my e-signature. But now that's something that's really being focused on. And so, as lead forms are being put together, it is really important that you provide an e-sign disclosure with a linked document that meets those e-sign formalities, as ridiculous as it is, and that the consumer is consenting to those throughout the process. And there's multiple ways to do it. Definitely speak to your legal counsel about the best way to do that. But, that's one of those things that really got attention called to it as a result of that rulemaking. And in the wake of that, we had the Bradley versus Dental Plans case that said that you can't get e-sign consent over a recorded telephone call because those e-sign disclosures have to be in writing. So that changed over the last year. Also, at the same time, the FCC had commentary in its rulemaking that said, we are not changing the do not call consent requirements, which is a prior express invitation to call somebody that's on the do not call list. But at the same time, the state attorney generals, I think there were 28 of them, filed comments to the FCC that said you don't have to change those prior express invitation requirements because those have always been that they need to be on a one-to-one basis. Now, that's not something courts have held, but it does have everybody now looking at the do not call requirement. So even if you're not using the regulated technology, you really need to just kind of dust off your consent rules and take a look at them again and make sure you're getting that prior express invitation. And I think the one-to-one is quite a stretch, especially in light of the 11th Circuit ruling. But we can't forget about do not call. I think a lot of people are saying, or had even said during the last year, we're not using regulated technology. We don't have to worry about this, but you do have to worry about do not call requirements.
Michele, I have a question for you before we look at the actual impact and where do we go from here? What are our perspectives in terms of moving forward? If we think about everything pre-Friday last week, I'm just curious, what have you seen over the last year, how companies prepared for it? And I'm specifically talking about lead generators and lead buyers in our industry. What have they done about it to be prepared? And what is the general consensus that you heard since Friday? Is everything out of the window, or actually people want to continue on that same path?
There are so many different flavors to the responses that happened last year and also in the wake of the rulemaking. And I think that people have very different barometers on the level of risk that they're willing to accept. And if it's something that's placed on the seller, I think that the companies that are providing them with leads that are not as conservative as they could be are not as worried about that. But the sellers they've been educated over the last year about what the risks are out there. And they've seen the uptick in TCPA litigation. And so I think for lead buyers, it's probably where the biggest shift has been. And I don't think that's going to change. I think that because of this rulemaking, it really required them to go back and evaluate what their lead forms look like. Are they going to be able to pull these out if they get sued in court? Do they have sufficient proof to show that they had valid consent with good language? And they paid a lot of attorneys to look at a lot of lead forms over the last year. So, it's really been all over the place. I did hear a lot of celebration, and then, I'd be like, well, guys, I understand why we're going to celebrate. This is great. Let's take a weekend to do that. But Monday, we need to get back to looking at what you have out there, because really nothing has changed for plaintiffs. And I think that we'll see some AGs out there that are really trying to send a message and they have the robocall task force that's out there, and they have been very active.
So one other thing I think we've seen with this change is so one-to-one consent is no longer a requirement under the TCPA, but there are still some requirements related to one-to-one under CMS regulations. Is that something you could expand on a little bit for us?
Yeah. So if selling CMS regulated products, so basically all those products that are being sold during open enrollment or Medicare, then there are CMS requirements that say you have to get consent on a one-to-one basis with the insured to share the information you get in the lead process with insurance companies. And so the one-to-one did not completely go away for that industry. They're still having to comply with that. And the irony of the fact that was the Insurance Marketing Coalition that was successful, these rules still apply to them, does not escape me. But the difference is it's not TCPA class action lawsuits that they're looking at. It's the CMS rules, which have less bite to them. But the irony is beautiful.
Those requirements were not January 27 as well. Those have been into effect since October.
That's right.
In a lot of changes in terms of how the whole Medicare industry, I think, has been adopting that, and some nice shares perhaps for later this particular session as well to talk about.
Yeah.
I wanted to actually direct a question to you, Eli. Michele was referring to the fact that many people had a first response of large celebrations. I know we were texting last weekend. How did you personally, and how did Verisk welcome the news last weekend?
Yeah, so I mentioned earlier kind of that feeling of whiplash, which I think a lot of us went through with this change. The reality is it's mixed emotions, right? Because I would go back to when we first started this webinar series and started trying to kind of understand what the changes were going to be and share with the industry how we were preparing. We talked then about how, I felt like the intent of the regulation was correct. The spirit of what I think the FCC was going for was good, right? We can all hopefully agree that consumers should be giving clear and conspicuous consent. They should have the ability to actually know who's going to be calling them, and avoid unwanted calls. So like that, if that's what we're targeting, that's a good thing, right? So I think like many of us have felt good about the direction with that. At the same time, the way the regulation was written, the specificity of it, I think, created a lot of problems for the industry that were not really consistent with that intent and with that spirit. To me, the two big things that stand out there have been on the one hand, the specifics of one-to-one consent required website operators and lead generators to kind of adhere to very specific and stringent requirements for what consumer experience to create, which I would argue is not really the place and the purpose of the TCPA regulation, which again is speaking to consumers should give consent, they should know what they're agreeing to, and they should not be receiving unwanted calls. There are a lot of ways to create consumer experiences that stay true to that spirit without being so regimented in exactly how consent needs to occur, the order of it, and whether it's one-to-one or multiple parties at a time. So to me, that was one big challenge. The other thing that jumps out to me is I think the regulation as it was stated had real potential to create some anti-competitive dynamics for small businesses and for companies operating brands that are less well known. The lead gen ecosystem and the third-party lead channel has traditionally been a way for companies to compete with larger brands that have more direct marketing, direct-to-consumer presence. You can buy leads and actually compete for a consumer's business that you otherwise might not have been able to get in front of that person or have the same share of brand presence with some of the larger players. So requiring one-to-one consent in this way, I think, had real potential to kind of push people out of the market, and so that was a problem. All of that said, right, we're here, and our role as Verisk Marketing Solutions, right, has been to operate as a neutral, trusted third-party standard to help our customers, lead buyers, and lead sellers comply with whatever that regulation is. So we've been working for the past year or more to try to prepare and get ready. And so there's been, so much time and energy invested in building the technology to support verification, to support the way the industry was shifting here. And so, it's, I think, difficult to see at the very last minute, all of that work kind of come to a halt and suddenly everything changes and we're back to where we were before. But I think, on the other side, there's been a lot of learning through going through that process and some good things I think that are coming out of it, which I'm excited for us to talk more about and hear, how some of the positive results that I think you guys have seen at PX. And I know we've heard from other partners, they've been seeing positive innovation that came out of this whole experience. So silver linings in that. And I guess overall mixed feelings about the pros and the cons of where we ended up here.
I agree with a lot of the points that you said. From our point of view, we definitely welcome the news in generally speaking, and I think that's because as an industry, we should clean up our act a little bit in terms of doing it ourselves. We don't need more regulations to step into the industry to make things harder. I think this was definitely one of the regulations that would make things a lot harder and create a larger barrier of entry for new players to enter as well. It's already not too easy, I think, to generate good leads today or to buy good leads today. So with more regulations, that only gets harder and the industry potentially only gets smaller in terms of the players that are really good at it. So we definitely, we had a Saturday of celebrations, I would say, because of that. Having that said, looking back, I think the last year, it's perhaps also a wake-up call for the industry where the industry definitely came together in the last year. And we've done these webinars together, which I think were great. But I think outside of these webinars, a lot of companies really got together in terms of how do we solve this and how can we actually think about consumer experiences, but also experiences for all players involved to make it better. And there's definitely been quite some innovation in the space in order to tackle that, which I think is great. And I think as an industry, that's, that's really positive. Question is, can we actually do that by ourselves without, having regulatory bodies step in? I think the answer is yes, but hopefully this was a wake-up call in terms of what we can do to make those improvements. And generally speaking, I share your thoughts. When I read the news, the first thing I thought was we spend a lot of time from our product roadmap to make sure that we can facilitate all these complex flows and make sure that a one-to-one consent is present during the opt-in. But at the same time, I think all the functionality that's been built by many players can be reused in very positive, innovative ways today. And that's a good thing, right? That's a good thing that perhaps otherwise we would have not spent that much time on in order to focus on that. I'm excited to share that a little bit later, this particular webinar, what we've seen indeed in the results. But overall, yeah, overall positive and welcoming the news. Michele, have you heard like people that are very cranky since last week because of this, or that are actually pretty upset that this happened?
I think that, like, if I had the most prevalent kind of reaction to this, it's been more of the, well, what do we do now? People are just really trying to understand, what does this truly mean? And I think for the software platforms, there was definitely that they spent a lot of time and effort on this. But this is the thing. And so I really strongly feel that that was not wasted, because now that the industry has shown that they can do it, I think that those companies that are very risk averse, and I think the risk aversion level has gone up much higher over the last year, they're still going to be looking for those companies that made these changes and can give them the defendable position they need if they get one of these, very active class action attorneys or plaintiffs that try to go after them. And the bigger you are, the bigger your target. And those companies are still going to want to use that technology that's been built over the last year. I don't see that going away.
Makes a lot of sense, and I think it's another, it's another point towards some of the good things that have come out of this and the innovation that we've seen, and so maybe that's a good opportunity to transition here, because Bas, I think I've alluded to it a few times here. You guys have come up with some learnings, and I think have a couple things to share that you've seen brands that have been doing this well, succeeding with one-to-one consent in the run up to last week, and be interesting to share that with everybody and show what you guys have learned.
100%. Yeah. And before I share some of the learnings, maybe good to talk about what we had focused on in the last year in terms of building a solution, and also what we focused on together with Verisk Marketing Solutions. So we built a couple of components within PX to make the matching process very easy for a one-to-one consent to appear in real time on the lead generation form for the consumer. So when the consumer is shopping, a lead generator could ping the system of PX and see what brands would be available and show the particular brands in real time to the consumer. And the more data was collected along the path of that consumer experience on a form, the more accurate that could be. If you start with a zip code or a vertical only, it would be very generic. But if you collect all the information of the consumer, only eligible brands would be shown to the consumer. So our solution in that regard, we called it brand explicit consent, where the brands would be listed to the consumer. And before I share some of the results, I think good to explain one more time the different implementations that we've seen from lead generators in the market, because there's been a lot of different flows. We talked a little bit about the innovation that have been tested, have been deployed, and a lot of different players in the market have focused on one of the particular flows that they felt was best for their business. So in, for example, auto insurance, a lot of the lead generators really focused on capturing a TCPA that would only list one particular brand in that TCPA. So instead of showing a link with a lot of companies behind that particular link, one company would be placed and it would be an exclusive consent for the consumer. The difference, however, was that the consumer would not select that particular brand, and it would basically be a hard-coded TCPA. In other verticals, we've seen more flows that I'm showing on the screen here, where the consumer were presented with multiple options, and those multiple options could be selected by the consumer. And the consumer actually had a proactive step that they could pick one or multiple brands. And I think generally speaking, when a brand would be hard-coded in the TCPA, so instead of the TCPA link, it would be replaced with just one brand. Generally speaking, not much has changed. Lead conversions on the flow from a click to a lead did not change much. The conversions from a lead to a sale did not change much, because if that brand is just hard-coded and listed in the TCPA, the consumer would still not pay that much attention to it, right? Where we have seen a massive change is in this particular flow, where the consumer would be presented with options, and then the consumer would select one or multiple options or skip these options. And we talked a little bit about that with Wisdom companies in one of the previous sessions as well, where Wisdom was specifically testing one of these flows, where they also saw a drop-off where consumers were not selecting any brands anymore. The question obviously is, would those consumers that would have dropped off and skipped this particular step actually converted to anything afterwards anyway, if they didn't want to be matched to the brand, right? So the consumers that did match a brand, that did select a brand, couple of interesting results that I would love to share for three different verticals. And the first one is Medicare. So Medicare, there's a lot of activity in the Medicare in vertical, specifically going through PX, from calls to leads. If I focus only on the lead side, what we have seen is when a standard TCPA is being used versus a one-to-one consent where the consumer can select the particular brands they want to interact with, conversion rates shoot up by about 95%, which obviously is massive. That means that the leads that are being purchased by these brands convert 95% higher, but it also means that these leads are actually 95% worth more money, putting a higher dollar amount in the pocket of the lead generator. So that was a big one, and that was a super interesting one for us to see. And we started seeing this throughout AEP when October 15 started with these new regulations that CMS required for one-to-one consent. 95%, I think, is huge, right? The second one is pretty similar. These have been live for a shorter period of time. I believe it's 45 days or so by now, but similar results in windows and roofing. So in home improvement verticals by themselves. We've seen a lift of 85% from a lead to a sale conversion when the consumer is selecting the brands that they want to interact with. Another one, HVAC, somewhat similar in terms of home improvement, but we've seen a lesser lift in that particular vertical, only 28%. This could be related to the fact that this particular case was pretty isolated to the number one brand in HVAC. So there could have been a high recognition already by the consumer when they would have received a call in the standard TCPA as well. But nonetheless, pretty positive result. So as a short summary, what we're seeing is that anywhere from 28% to 95% lives in conversion rates. So that backs the question, should we not continue actually testing this? Should we not strive to provide a better consumer experience in some of these flows in pockets where it makes sense for the consumer, but most importantly as well for all the players that are within the chain, for the lead generator that can actually pocket a higher amount of revenues on a per lead basis, which hopefully would result in higher yields as a whole, but also for the brand that's actually purchasing the lead with these higher conversion rates would result in much more efficiency on the call center perspective, on a full process perspective. So I'm curious, Michele, if any of these actually surprise you, or this is kind of like what you've expected. Maybe it's something that you've heard from other players. But our point of view is definitely it's not required, but it's optional. And optional means that we should probably continue to test with these type of innovative flows and see if there's pockets of media where these type of one-to-one consent flows should be presented to the consumer.
Yeah. I think consumers have gotten a lot more sophisticated, right? And I think that they are very leery about providing their information because of bad experiences they've had in the wake of filling out consent forms. So I'm really not surprised by the conversion results that you're getting. And I also think that, you know, the higher intent leads like that are very valuable, right? So the conversion rates, as you've shown, are much higher. And so I'm not surprised by that. I think that's something that we've known for a while. I just think until the FCC took this action, people weren't willing so much to invest in it. And so I think that is one lasting good thing that's come out of this past year.
Yeah. Hey, Bas, I'm curious. So in those examples, right, you're seeing much higher conversion rate for the brand explicit consent flow. I assume that's also leading to higher pricing for those individual leads that kind of coincides with the higher conversion and the higher quality. Is that a safe assumption, or like are you seeing that consistently and buyers and sellers are agreeing to that? Because I think in the past that's always been a challenge with, you know, getting higher quality. But if a brand's not willing to pay for higher quality, that's where it starts to break down, and you end up back in the game of just give me as much volume as possible at the lowest price. But it seems like maybe you're starting to crack that that challenge.
Great question. I'll answer that in two different ways, because I think a lot of companies have tried these particular flows in the last 3-4 months. And one of the big questions of lead generators was, am I going to be paid more? And at certain instances, I think generally in the industry, people said yes. At certain points, people said no. I know Wisdom actually, like in one of the previous webinars, referred to it that higher conversion rates did not result per se right away for them with their direct brands to a higher payout on these leads. For everything that we're doing through PX, I can say yes, a higher conversion from a lead to sale would result right away in a higher lead price for the lead generator, because we're operating on a dynamic pricing model. That's one of the backbone engines, I would call it, from PX, to ensure that leads are being priced to what they're worth. And if leads are worth more, they're being priced right away to what they're worth. So in these cases, in these examples that I'd shown, that meant that leads were priced within a matter of days to what that lift brought to these particular placements, which I think is great. And as an industry, we should reward higher conversions. We should reward if a lead is more valuable. I know that's challenging for some of the players still today, but it's the only way to actually make a breakthrough on that. The other thing that I would state as well, which is challenging for a lot of lead generators, if the lead was rejected, when the consumer only selected one brand, when that lead would have been rejected, that lead would have fallen on the floor. And I think it's still a great opportunity today to think all together how we solve rejection rates, how we make sure that matching is being improved to a consumer, where a consumer is not being matched or not being shown or matched on the background, if that consumer cannot be interacting with the brand. So if it's a current customer, if it's a duplicate lead, whatever the reasoning is, we should get smarter, and we should have systems that are better integrated between all players to ensure that that's being solved, because otherwise lead generators are still being penalized with that structure.
Yeah.
Eli, curious to revert it back to you. I know Verisk Marketing Solutions has done a big push to get everyone ready in the industry, and kudos how you guys were able to navigate through that. Are there some learnings that you're seeing in terms of the implementations and the abilities for companies to verify if a brand was present on the opt-in?
Yeah, for sure. And to your point, definitely kudos due to a lot of folks from our team that have been heavily focused on this for many months. Ryan Johnson in particular, who joined you guys on this series while I was out. Ryan leads up our product team for our TCPA Guardian solution, and has had hundreds of conversations and meetings with customers the past few months, and has been working diligently with our engineering team to prepare everyone for this. So yeah, I think, you know, we were on a path and kind of running towards making sure that every customer or lead buyer or lead seller has the ability to verify not only that a TCPA disclosure was present, and that the consumer consented to it, but also that a specific brand was present and that consent associated to that specific brand had been provided in a one-to-one format for the consumer. So those capabilities, we've built them, we have them at the ready. We've also integrated with PX's platform, so that lives on, and we can still help customers comply, with one-to-one consent flows if there's a key need for that, right? Where not just because of the TCPA regulation, but because you want to make sure that if you're paying more for a lead that's based on one-to-one consent and brand explicit, you can verify that up front using that same feature set. And then for everything else, right, as we talked about earlier, it's still just as important today to make sure that you have prior express written consent from the consumer before you start calling them. So we expect customers to be continuing with our TCPA Guardian capabilities to verify that and to prove consent after the fact if or when there are issues. And as Michele noted, the TCPA landscape and the amount of litigation continues to go up. I don't think it's going down just because of this this change with the one-to-one consent order. So we're still at the ready to help the industry stay in compliance and prepare for the future.
I'm muted. Michele, have you been busier last week, or has it actually been a little bit more quiet than you anticipated a week ago?
The last time I was probably this busy was, gosh, 2016, 15-ish, when I was GC of PACE, and we were successful at getting the definition of an ATDS overturned at the DC Circuit Court. And so yeah, this is probably the second busiest that I've been. A lot of it's just been a lot of speaking like this, just helping people try to understand what's going on out there. And something I haven't talked a lot about, but you guys have made me think about this a little bit more, is there's been a lot of other things that have happened in the last year or two, and the robocall mitigation obligations for carriers are being taken very seriously. And so it's probably not the regulators that are the biggest issues now. It's whether those calling platforms are having problems with their carriers because of the types of calls that some of their customers could be making. And so the policing is being done at a whole different level than it was before. And you've got the campaign registry, which is requiring one-to-one consent as well. And so it'll be interesting to see what happens with the industry. I think especially with the robocall mitigation of the carriers, we're not likely to see them pull back much. And the industry traceback group has been busier than ever. They're a group that is responsible for using STIR/SHAKEN to trace back calls to the originator. And so being able to prove that you have consent and the consent is valid and it's clear and conspicuous and it was readily apparent to the consumer is still going to be so key. So some things have changed, but the principles are still there.
Thank you so much, Michele, not only for joining today, but joining all these webinars in the last couple of days. I think spreading the word on the updates, what it means, but also what it could mean moving forward. We truly appreciate you joining us today and sharing that with a wider group.
Thanks for inviting me.
Thank you so much, Eli. It's great to have you back. And I'm curious when our next webinar is. Who knows what happens in the next week in terms of news. But thank you everyone for joining today. We had a couple of questions in the chat. I apologize for not getting to those. We'll make sure that we're following those up per email after this particular session. Thanks, and see you soon.
Send baby pictures, Eli. Bye.
Got it.